Dear friends, today we are going to discuss set off and counterclaim. Whether these two terms are same or different. As you would have noticed, in every commercial dispute, the defendant tries to avoid making payment against the claim by raising its own claim, which at times may be set off or counterclaim. In which situation the claim of the defendant would be treated as set off, and in what other situations it would be a counterclaim, that we will discuss today. And what are the implications? See, if the defendant's claim is treated as set off or counterclaim, how the law deals with the two situations, and what are the privileges to the defendant if his claim is set off, or what are the disadvantages or advantages if his claim is treated as counterclaim. So that we will discuss today. We will find out the similarities between set off and counterclaim, and also the different treatment given to the set off and counterclaim in any civil dispute, particularly in arbitrations. In any commercial dispute going through adjudication by arbitrations, the defendant tend to raise set off or counterclaim as a measure to defend his own liability. So let's delve into this topic. So the law dealing with set off and counterclaim is set out in Order 8, Rule 6 of the Civil Procedure Code. Rule 6A deals with counterclaim and Rule 6 deals with set off. Within set off, there is another subset of the nature of claim which at times is treated as equitable set off. And to deal with the equitable set off, we also need to refer to Order 20, Rule 19, Sub-Rule 3. We'll deal briefly with the equitable counterclaims as well. Let me share with you the text of the CPC dealing with claims and counterclaims. First, let's see Rule 6, Order 8 of the CPC. It says, where in a suit for recovery of money, the defendant claims to set off against the plaintiff's demand any ascertained sum of money. We need to pause here. Ascertained in the sense it should be a known amount. It can't be an unknown amount and just a claim. It should be a clear, ascertained sum of money which the defendant is pressing as a set off, and it should be legally recoverable from the plaintiff, not any other person claiming through the plaintiff, but from the plaintiff. And another important aspect of set off is that both the parties, the plaintiff and the defendant, should fill the same character, in the sense in both the plaintiff and the person raising set off, in both the transactions where the main claim relates and where in the transaction to which the set off relates, both transactions should be of the same nature, and the character of the parties, in the sense the involvement of the parties should be of the same nature. Let's take an example. Suppose there is a company which supplies material, and the buyer and the seller have entered into a long-term supply agreement. And then from time to time, the buyer places an order on the supplier. Now, each purchase order read with the master supply agreement can be treated as a separate contract. But since the character of the parties in all the purchase orders remains the same, the claim relating to, say, purchase order number 2 can be raised against the plaintiff's claim relating to purchase order number 1, provided the character of both the parties is the same. In the sense, the nature of the transaction is the same in which the set-off is claimed and the transaction in which the main claim is raised by the plaintiff. So these are some of the important conditions to be fulfilled when we are raising a set-off. Now, let's see what are the conditions for counterclaim. When any set-off will not be treated as set-off, in the sense it becomes a counterclaim. See, in counterclaim, the nature of the transaction need not be same. As we discussed, the most important aspect of set-off is that both the parties fill the same character as they fill in the plaintiff's suit. Now, this condition is not there in Rule 6A, meaning thereby that a counterclaim can be totally unrelated to the transaction to which the plaintiff has raised a claim. Okay, let's understand with an example. Suppose there is a company doing EPC construction project. It is a construction project on EPC basis. And there is a company which is a steel producer. And the steel producer wants a new factory to be constructed by the EPC contractor, and for which the EPC contractor is awarded the contract. Now, this company constructs the factory, and then there is a dispute. Now, what happens is that there are other transactions totally unrelated to this EPC contract, wherein this steel producer supplies iron and steel to the EPC contractor for EPC contractor's other project, not of this defendant. Now here, suppose there is a dispute in the EPC contract where the steel producer has failed to make certain payments and the EPC contractor raises those claims before the arbitrator in its statement of claim. Now this contractor, very same contractor, has defaulted in making payments against the supplies of steel for his other works. Now, whether the defendant can raise those pending payments as a counterclaim in this arbitration? The answer is yes. It should be between the same parties, but may not be relating to the same contract. And here, since the nature of the parties, character of the parties have changed. In the first transaction in the EPC contract, the party A is a contractor, party B is the employer or the owner of the factory. Now, in other transactions, the party B is the supplier of steel and party A is the buyer of that steel. So, in both the transactions, the character of the parties is different. Therefore, it cannot be treated as set off and it falls under Rule 6A as a counterclaim. Now, what are the implications? See, in set off, the arbitrator or the judge would find it difficult to say that he will not deal with the set off claim. Because what happens in a set off is that lot of evidences and documents may be which are relevant to the main claim would also be relevant to the set-off. And it would not be as advisable to have two independent legal proceedings or two arbitration proceedings, because ultimately there may be, and generally there is a lot of overlap between the two claims, contesting claims, and therefore to avoid multiplicity of the litigations and to have a comprehensive resolution of the dispute, it is advisable to deal with both the main claim and the set-off together. The same situation may not be there in case of Rule 6A. And here, the plaintiff can object to the counterclaim. The counterclaim is of such a nature that the defendant should initiate its own independent proceedings. In the sense, the plaintiff can say that by raising a counterclaim, there is no benefit except that the parties on the both sides are the same. There is no other commonality between the plaintiff's claim and the defendant's claim. And mixing the two may complicate the matters instead of simplifying them. And here the court will have slight discretion, similarly the arbitrators, to say that the counterclaim should be raised as a separate proceeding. This cannot happen in a set-off. So that's the first difference between set-off and counterclaim. There are other dissimilarities between set-off and counterclaim. We'll deal with that. Another difference between set-off and counterclaim is that a counterclaim can arise before or after filing of the suit by the plaintiff. Let's understand with the example. Suppose the plaintiff filed suit on 1st April 2024. And the cause of action for the counterclaim arises on 15th April 2024. And the written statement filed by the defendant is on, say, 30th April 2024. Since the written statement is filed after the cause of action for counterclaim as the reason, so that cause of action was after filing of the statement of claim by the plaintiff, the defendant can still raise that counterclaim. But in case of set-off, the cause of action for set-off must have arisen before filing of the suit or the statement of claim in case of arbitration by the plaintiff. That's another difference. There is another important difference between treatment of set-off and counterclaim. What happens is that sometimes the main suit is dismissed or withdrawn by the plaintiff. In that case, the claim for set-off will also go away. But in case of counterclaim, even if the plaintiff's claim is dismissed or is withdrawn, the counterclaim can proceed independently. With the dismissal of the main suit or withdrawal of the main suit, the counterclaim doesn't fall away, but the claim for set-off falls away. That's an important difference between counterclaim and set-off. Now, let's deal with the equitable set-off. As we just saw, in a claim for set-off, the sum of money should be ascertained. Now, just take an example. There is a contract which do not provide for liquidated damages. Though it says the defaulting party will be liable to pay damages, but there is no quantification, there is no formula, there is no parameters given. Therefore, there is no liquidated damages provided in the contract. Now, in this case, since there is no liquidated damages, the damages need to be ascertained. If there is no certain amount of damages. Now, in that case, what happens is that the defendant may still raise the claim for set off arbitrarily or according to his own parameters, quantifying its damages. But then now the court has to adjudicate and ascertain this amount of set off. Therefore, this kind of set off is treated as equitable set off. Now, here there is a bit of discretion with the court, and therefore the court has to exercise its power under Rule 19(3), Order 20, Rule 19, Sub-Rule 3. While disposing of the suit, the court will quantify the amount of set off and will allow against the plaintiff's claim. Here, in a real dispute, while we are arguing a suit, we may also refer to Section 151 of the CPC, which is slightly akin to Article 142, which empowers the Supreme Court to do complete justice. Here in 151 CPC, the High Courts have the power to deal with this kind of situations, and the High Courts have inherent power to deal with the situations which are not exactly provided in the CPC and which are essential to decide any suit. So there, this Section 151 read with Order 20, Rule 19, Sub-Rule 3, the court will basically decide on the quantum of the set-off, where the claim, the amount of set-off is not ascertained, and therefore it is treated as equitable set-off. Hope this is of some help to you in understanding the difference between counterclaim and set-off, and within set-off, in what situations it may be treated as equitable set-off. Thank you, friends. We'll meet you with other topics. Let me stop sharing this. These are the rules that, as we just mentioned at the beginning, this is the relevant law dealing with set-off and counterclaim. With this, thank you for your time and attention. I would like to just clarify that the views expressed and comments made herein should not be substituted as a legal opinion or advice, and I would encourage you to have your independent view and take expert advice while dealing with your own matter. Thank you. Thank you for your attention.